No, I don't know whether everybody could hear that. I just got an announcement.
Sorry about that. So go ahead.
And then the last thing I wanted to kind of mention with respect to contract protections for speech or contract limits on speech are non-disclosure and non-disparagement agreements. Of course, they specifically are aimed at limiting the speech of employees or former employees, but I wanted to note a couple kind of new or new-ish limits on their use. So there's the federal Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, FSASHA, which just rolls off the tongue. That specifically relates to pre-dispute arbitration agreements, but because those agreements can contain confidentiality provisions, it's got some relationship to employee speech. And then also the NLRB's recent decision in McLaren-McComb, which held that employers may not proffer severance agreements that contain kind of broad waivers of NLRA rights. And that is true under McLaren-McComb, whether or not the circumstances surrounding the employer's offer of the severance agreement are independently coercive. So that's my kind of quick overview. So let me hand it back to Evan to kind of move us into the next part.
Thank you very much, Charlotte. Let me pose a hypothetical to the panel. A pro-life employee posted an article on an internal company platform proclaiming, quote, "Abortion is the leading cause of death around the world, killing more people than cancer and disease in 2022. The Post also noted that the company's health plan provided coverage for abortions. Company was relatively small, has not developed any comprehensive policies about what types of speech are permitted in the workplace, but HR has received a number of complaints from employees who are pro-choice, complaining that the article is harassing based on their personal, political, and religious views. Charlotte, I'll throw it right back to you. Are there protections that cover this type of speech in the workplace?
Potentially. I think maybe somebody else, maybe Dan, is going to talk about labor law. So I thought I would talk about Title VII a little bit. So Title VII protects against discrimination based on religion, and part of that protection includes a requirement that employers provide reasonable accommodations of employees' religious belief or workplace religious exercise. So this hypothetical made me think of a older 8th Circuit case called Wilson v. U.S. West Communications. The case had to do with an employee who began wearing an anti-abortion kind of pin on her clothing every day. It was a fairly graphic pin. It had a picture of a fetus, very upsetting to other employees, sometimes because of their pro-choice views, but sometimes because of just other kind of things that had happened in their lives. And so, there was a substantial amount of kind of controversy that the employer wanted to kind of deal with or, kind of respond to. So employer tells employee that you can't keep wearing this pin, offer some alternatives, employee doesn't find them acceptable, litigation results. So the question is, does the employee have a right to have her religious belief that she wants to wear the pin accommodated? Two questions end up being important here, and I think they're both potentially related to this hypothetical. One is kind of what is the real scope of the employee's sincere religious belief, and does it extend to a kind of religious, compulsion and religious obligation to actually wear the pin, or is it instead the case that the employee has sincere religious beliefs about abortion, but the decision to, wear the pin or make the post is not kind of required by those beliefs, but just something the employee kind of wanted to do. And then the other question is, what's the reasonable accommodation obligation? So that's kind of a bit of a moving target in the Supreme Court's recent decision in Groff. Up until Groff, the religious accommodation obligation had been an obligation, had been quite limited, right? So the court had previously interpreted undue burden to allow employers to refuse religious accommodations that impose more than a de minimis burden. In Groff, the court says that's not a correct interpretation of the statutory phrase undue burden. Instead, the question is whether the accommodation would result in substantial increased costs. I think it's genuinely difficult to kind of translate substantial increased costs in a context like this, where the cost imposed on the employer is sort of a lot of turmoil within the office, and I don't think Groff exactly speaks to that question. But those are kind of the twin things I'd be thinking about with this in this context, right? Is the post religiously required, and then what's the cost of the potential accommodation?
And Charlotte, what would you, sorry, I'm out of turn for a second, but with respect to the first piece, how do you think the cases shape the way the employer can figure that out? So I have clients who will want to engage in something that feels a little like the interactive process. I mean, folks who are in love with Hardison, which is the prior case on undue burden, love that it said you can't impose a diminished burden, and it put employers in a place where that first prong, okay, fine, it's compelled, but we don't have to do very much to accommodate you. Now there's much more focus on the first prong. And I wonder whether you think the court is pointing us toward eventually an interactive process that feels like what employers do under the Disability Act, where you start to ask. And then, of course, you've got all these cases about religious belief, which tell you it doesn't have to be what the church says. It can actually be your own private sense of what God is telling you to do. So an employee saying, I have to wear this button because that's what I believe, maybe in a position where that first question is answered already. Anyway, I'll stop there. I'm just interested in what you think.
So I agree that one effective Groff will be to put more pressure on the sincerity, on the is it religious and then is it sincere, kind of set of related questions. And I also agree that Groff points towards an interactive process with respect to the accommodation. So my sense is that employers will have to come up with ways to, sort of ask an employee, can you explain your religious beliefs to me and tell me what they require? And then, to make some, and then to attempt to figure out, right, whether they're being sincerely asserted. In this case, in sort of these hypotheticals, they don't read to me like it's likely that the employee is being insincere, although it may not be the case that the posting or the button or whatever is religiously required. But it makes me think of, a case like Cloutier v. Costco, right, which is an employee who, in response to an employer rolling out a policy that says you can't have kind of like piercings or kind of other body modifications, says, well, I'm a member of the Church of Body Modification, and the kind of timing of things makes it seem like it may have been brings sincerity into question. The court in that case, right, says, well, the accommodation would be more than a de minimis burden, so we don't really need to figure out sincerity, right? After Groff, I think you do need to figure out sincerity, and I think that's really difficult.
Well, let me pose, Dan, what is your take? Is this speech protected under the NLRA Section 7? Is it protected under any other federal or state law? What if it didn't make any reference at all to the health plan?
That would be significant, but let me try to see if I can address this. I think it's a very close call. As you said in the introduction, I practice labor law primarily on the union side, so that will likely influence as I try to review what I think is the law and the way to analyze this. The hypo says that it's one worker who has posted this pro-life statement. We also know that the employer, it's a small employer, and the employer has a healthcare plan. I think a way to analyze this before we look at it is to flip the facts. Now, as the general overview of the law, obviously the NLRA protects speech, but it protects it only to a certain extent. There are Where you speak, what you speak, how you speak, and when you speak are critical elements of whether it in fact is protected. And a few of those elements come up in this. As I said a minute ago, I think it'd be interesting to flip the facts. Let's say that it was one worker in this company that had a health insurance plan, but abortion was not covered under the plan for whatever reason. The employer, for religious reasons or political or whatever, just doesn't have abortion covered. And a worker posted a sign saying it's critical for us that abortion services be provided. How would we, and the employer didn't like the message and retaliated, fired, suspended, terminated the worker. How would we view that? Well, I think that's an easy case to analyze, because the statement is being made concerning health coverage, and the implications of health coverage is also cost. So you're dealing with two critical elements that are terms and conditions of employment of those employees. And we would say in that circumstance, there's no question, but that this is a protected statement. As Charlotte mentioned, the analysis starts, of course, with concerted activity, and then it goes to mutual aid and protection. While it's one worker making the statement, and in this case right now, I'm talking about the pro-choice statement, clearly under board law, this would be viewed as applying to a larger set of workers, particularly because it references healthcare. And if you go to mutual aid and protection, that focuses on the substance of it. And here it's, again, healthcare and costs. So it applies to what are in fact mandatory subjects of bargaining in the workplace. So there would be no dispute that had met both the concerted activity and it met the protected mutual aid and protection standard, and it certainly wouldn't violate any of the other disloyalty or other elements which could otherwise reverse an otherwise protected statement. Now let's go to the hypothetical here. The worker in this case says that it gives a statement which says that the plan should not contain abortion services, should not contain. Now, it references and it addresses the healthcare plan. So in one level, right away, we are dealing with something that is a workplace term and condition. But there's a distinction between this statement and the statement that the pro-choice worker made, because in this statement, what the worker is saying is that there should not be a service provided. In fact, under the plan, any of the participants can choose not to have abortion services and not pay any costs associated with it. So it's not addressing healthcare or the costs associated with healthcare. The statement is saying this shouldn't be in the plan for either religious or political reasons, not for healthcare or cost of healthcare reasons. And so the board could say, in a case like this, that it is the statement of the pro-life employee is too attenuated from the mandatory subject of bargaining, it's too attenuated to the health care of the employees in the workplace. Again, in contradistinction to the pro-choice worker who is directly addressing the healthcare coverage of a worker and the cost of the healthcare coverage. Obviously, if the plan provides the service, then it's going to pick up a certain amount of the cost of it. So there is a distinction, and the board here could say that we don't find this statement of the pro-life worker protected because it doesn't directly affect an immediate term or condition of employment that the workers face. Because again, the workers already in effect have the term or condition because they can decide not to take the service or pay any costs associated with the service. I think as coming from the labor side, I think my preference would be just because for the expansion of speech, because speech is so critically important for workers and for the labor movement. I would hope the board would side and protect the statement, but I think there is a basis for it to say that it is not protected, it is too attenuated. Also, it doesn't, the other exceptions which the board has created for creating dissension in the workplace, in any way safety, related to dissension among workers, I think those would not be grounds to set aside protection for this, because again, it doesn't directly create a situation as the board, for instance, in Home Depot defined it, would have created immediate dissension and tension, which might result in some safety amongst the workforce. That's not present here.
So Dan, let me.
I think that the board might find this protected, but there is a basis to say that this is too attenuated and not protected.
So Dan, if you were in contract negotiations representing one of your unions with an employer, and the employer proposed to put into its health benefit plan coverage for abortions, or proposed to have an exception from its plan so it did not cover abortions, what would you advise your union in that situation?
Well, the question would be, what do the workers want? I mean, if the workforce wanted to have those services available, and again, any worker could say, I'm just not going to avail myself of the service. But if the workers in that employer wanted it, then I would argue that it's a mandatory subject and that we should push forward to negotiate for the coverage.
In a meeting of the employees that the union officials have just conducted privately, though, some of the employees have gotten up and been very vociferous in favor of keeping abortion covered by the plan, while others have said no. And now, what is the union's response to the workers?
Well, I think, again, the question is, what do the majority of the workers want? You know, in O'Neill versus the airline pilots, the Supreme Court said the duty to bargain, the union has a right to make decisions based on what the workers' legitimate desires are. So if the majority of workers said we want that service, the union might go forward. By the way, there's another element that I didn't discuss in this, but for the pro-life employee, if in fact it's not about actual health coverage or the cost of health coverage, this may, and it's for a political or religious reason, this may be not a mandatory subject to bargaining. This may be permissive, in which case the union could bargain that, but it certainly couldn't strike over it. It may reduce it if the motive is if the goal is a religious or political goal, that it's not a mandatory subject.
So, Josh, how would you advise your management side clients with respect to the underlying hypothetical?
Well, I'm going to start with a kind of observation, which is that having people from different perspectives talk about the same thing is always so fascinating, because everybody's lenses determine what they see. You know, Charlotte starting with the notion that maybe there's a religious accommodation question in this hypo. I think it's right, but not necessarily obvious. Dan sees this as a negotiation over somebody's opinion about the health benefits plan. In all fairness, I didn't see that at all in our hypothetical, because the person just posted the fact that the health benefit plan provided that, but I see how he gets there, because that's how he gets here. And I listen to your question, Evan, and my thought is, well, what is my client asking me, as opposed to how would I advise the client? Because the client could be asking me a number of different questions. If the client's asking me Charlotte's question, which is, do we have an obligation to allow people to make this post? We haven't even talked about what the form for the posting is, how it exists, or why it's there. But do we have an obligation to let the person make this post? The first thing I'm going to do is, just as Charlotte did, go through the spaces that tell the employer that in all likelihood, speech on a matter of political importance in the private workplace is not protected. You can make your own decision. But then I'm going to go to the buts. And here I mean the things you got to worry about. And I'll talk a little bit about what I worry about and where it falls on a mattering scale. So the first is Charlotte's point, which is an employee says, well, I have to post this because my religion requires me to express these views. And as a consequence, you need to allow me to do this as an accommodation. And we end up right where Charlotte and I were in the back and forth, which is, okay, is it a sincerely held religious belief? And to what extent can a sincerely held religious belief include in it the announcement of the view? And then I go, and bear with me for a second, to an Annie Dillard essay in the book Teaching a Stone to Talk, where she talks about Christian witness. And Christian witness in some part of the country, as a matter of religious belief, requires the beginning of a conversation to be, do you accept the Lord Jesus Christ as your personal Savior? And she writes a wonderful essay about how this affects children. But the point here is that kind of outward speech can in fact be part of a sincerely held religious belief. And then you go into, well, what does it mean to accommodate it? And that takes us to a space that I think we're going to learn about from courts, and that we're going to, for a while, wonder about as employers. And that is, what does it mean when the expression of a belief, or, and I'll get there in a second, the expression of a political view impacts others in a way that has an effect, and perhaps a deleterious, I can't say it, a negative effect on their ability to participate in the workspace the way they usually would. And I think that's an open question, but I don't think that courts are going to ultimately take the position that the obligation to accommodate is so broad that it can create enormous disruption at work, and that the employer has to tolerate enormous disruption in order to accommodate. And I'll go to a space that you might not think of for this, but if you look at some of the early vaccine cases that talk about undue burden, one of the things that they talk, there's a Boston Children's Hospital case written by Judge Casper, where she talks about the impact of having unvaccinated people in a vaccinated population and the health impact. And we'll all remember that when you go through employment law doctrines in general, safety is this great exception, right? That's the one place where things can be minimally enough tailored so that you could fall into exceptions to the employment rules. And I think with various political issues now and some religious issues, safety is at stake both, and we have to decide whether it's just physical safety or emotional safety. But that's a long way of saying I think there probably is room on the religious space for the employer to comfortably say no and understand that there might be a complaint about that. But that wasn't even where I was before we started talking because of violence, right? The thing I focused on was the question of harassment, because I'm not going to say I'm comfortable with harassment, I'm not, but I'm comfortable a little bit with the law of harassment. And the notion that this posting might lead an employee to say, wow, I'm a victim of harassment, I absolutely buy that. Now, that then puts you in the position where you're talking to your client about whether that, wow, I'm a victim thing is actually a legal claim that they should worry about. And my view here is probably not. And the reason for probably not is because you have about harassment claims a requirement of severity and pervasiveness, and a posting on a place in an employer's web space that you either may or may not choose to go to is highly unlikely to cross that barrier. But that doesn't mean, and this is one of the spaces where, and Heidi will tell you, lawyers who represent employers have to think not just about, can I defend the case, but also about, is this a space where an employer would be well served by adopting a more aggressive approach than the law compels it to apply? And that's going to be a question based on my client thinking about what they want their workplace culture to look and feel like, and how they're going to develop a workplace culture that they're comfortable with. And I'll say two more things about that and then stop. So workplace cultures have been strained by speech recently in a way that is outside my memory of how things have been in the past. And you can start with a couple places we've talked about before. Workforces were forced to confront, and you can look at both at George Floyd, and I'm jumping to the case I want to talk about. In the wake of the George Floyd case and the Black Lives Matter movement, employers faced enormous pressure both to accommodate internal discussions and also, and this is different and a space that I think we need to think about, to make public statements about what they as an institution felt about a political movement. and are about a cultural moment, or maybe better said, about justice in the world we live in. And what that reflected, I think, is a change in workforces and their expectations and desires for the people who they work for. Those of us who are lawyers, I think it's complicated for, because we kind of do what our clients need us to do, and we're comfortable with that. But we have people coming into the workplace who want to work for employers who they believe in and who share their beliefs. And so they pressured employers to speak. And with respect to George Floyd, about which there's not a lot of room to say anything other than how can that happen in the world that we live in, employers were able, I think, to find spaces in which to make statements that largely satisfy their constituencies of their workers. Dobbs, though, presented a different problem, and employers trying to come to terms with pressure from their workforces to make statements found all sorts of different ways not to. And because of political nervousness and because of a sense of what it would do internally if they did. And I think that that's left us with an unanswered space that this hypo goes to. And that unanswered space is, how much is an employee, how comfortable can an employer be with creating some sort of online forum for the exchange of ideas? Is that a good thing or a bad thing? That's a cultural question. And second, how comfortable is an employer going to be in a space where people differ in passionate and deep and religious and other ways, going to be saying, no, this is what we think, which maybe employees want them to say, or we're not going to listen to what you think. Ultimately, I'm not sure how much of this becomes a purely legal question. I think a lot of the legal guidance that I give in this area, after I walk through the things that I worry about, and I've kind of outlined what those are, I'll say to the employer, at the end of the day, is your legal risk the thing that's going to make the decision as to what you're going to do here? I don't really think usually it is. I think usually the answer is going to be, what is it doing to your workspace to make a decision about this? What kind of work culture do you want to have? And here's where I'll stop, because this is it's something I believe in, it's something I worry about in workspaces. I think we benefit from having people who don't think about the world the same way. Remember what I said at the beginning about lenses? We've all been given the same hypo, we all see it different ways. The conversation is better because that happens. If we choose to work only with people we agree with, we will see less. And the workplaces we build, I think, will be less effective. But figuring out how in the present environment, which is charged in ways I think that it hasn't been in the past, to build workspaces where you can have differing opinions and bring people to a table together in a way that respects religion, gender, and to some extent, though not legally protected, importantly, ideology and thought, is, I think, one of the great challenges we all face together. The law is going to help us here, but it's not going to give us the answers.
Thank you, Josh. Heidi, this gives us a wonderful segue into what happens in corporate America. Looking at this as an in-house attorney, what do you see as the best options? What are you most concerned about? How do you manage these issues inside a big corporation?
Yeah, I will say I agree with Josh here. It's so interesting to hear everybody's lens and take on this. My job's fun because I get to take all these really interesting pieces of advice and thought from our outside counsel, and then I get to figure out, what do I actually do from a practical standpoint. So I think what I'd be thinking about here is, first of all, I would be thinking about practically, what do I want? And Josh is right. We would be thinking about what kind of culture are we creating? I would be thinking about the folks that are reading the post. And, a part of our hypo includes some employees coming to HR and saying that they're offended, they're upset by the post. It implicates religious views, personal views, political views. I would be worried. I know, Josh, you made the point about this maybe not rising to the level of a hostile work environment. but I would be worried about having one post and then maybe more posts or comments or debate that might get to a place that could create a hostile work environment. The quote that we have here could be interpreted by some people in the workplace as calling women who've had abortion killers. And I think that could be a very, very upsetting experience for women. So I would be looking at the balance, of everybody's different perspectives and how do we actually get to a place where we can all work alongside one another. And I think that your point, Josh, about how do we create those cultures? From a practical standpoint, my first step would be have somebody talk to this employee and say, hey, this is how it's landing with your coworkers. And it's very upsetting to some folks. Some women are feeling like you're saying they are killers or family members of theirs are killers. Everybody's got a different view on these issues. This is probably not a topic to be, posting about in the company's internal platform. And see where that conversation gets you. I've been very surprised very many years when you open the door to a conversation with somebody who's said or done something and their first response is, oh, I didn't mean to say it that way, or I didn't mean to hurt people's feelings, or I didn't even realize that it could be taken that way. And they're willing to kind of dial back or change their post or take it down without a whole lot of churn. So that's the dream scenario, that we have a really good conversation and this gets either revised or removed. From there, I think that I would be thinking more about, is there areas in which I would take a risk? Like, would I take a risk on the religious accommodation area in favor of trying to create a workplace that doesn't bring up all of these controversial topics and allows instead for people to come to work and focus on the work and not have to be sort of confronted with controversial issues that they may not have been expecting to see on the company's platform that day. Yeah, I mean, it's interesting. I like the fact that we're looking at this. Dan, I appreciated your flip on the post and how that nuance of calling out that something is a benefit versus asking for it to be a benefit, and how that changes maybe the quality of the Section 7 protections. But yeah, this is not something that I would say go right for discipline or anything like that. This would be a situation where first and foremost I'd chat through, or somebody would chat through with the employee, what can we do here to kind of create a better culture. Now, we might run into an employee who says, no, I'm not taking it down. This is my post. These are my views. You don't have any right to tell me to take it down. And then I think I would listen, Josh, to your advice about, does this potentially implicate Title VII? I would take a look at the company's harassment policy, because many companies have harassment policies that are more restrictive than Title VII and contain clauses that, yes.
Can I ask a question? Because that's
yes.
right where you are is really interesting to me. The hypo says this is a small company with not a lot of policies. But one of the things I would think you might think about doing, particularly if you create a forum in which people can post things like this, is to create policies to govern the rules of engagement. And right. You look at the harassment policy, but maybe just talk a little bit about how that might work.
Yeah, so I'll talk first about sort of, if you've got a good harassment policy that has some commentary in there about the type of interactions or respectful, interactions and things like that, you might be able to leverage that. Facebook published its harassment policy, I think 8 years ago or something, where we had a much lower tolerance for any speech that implicated gender, race, religion, all the protected categories, than what the law would permit. But Josh, you're correct. Even outside of the harassment policy context, a lot of companies that do have these forums where employees can do internal posts, Slack channels, things like that, over the years, I think they've come to feel that we need some sort of policy that governs what is and is not okay in these forums. And that's really, I think, the key here is for clients who are generally want to have employees be able to have good dialogue and conversation and post their views and have these discussions, you're going to need something in place ahead of time, ahead of this post, so that you can fall back on that and say, hey, look, we have a policy around what is and is not permitted in the workplace. And our policy says abortion is one of the topics that is just simply off limits for discussion. It is too controversial and too distracting and too triggering and upsetting for too many people. So this is a violation of company policy. And that would be the ideal situation, to then just be able to simply take the post down.
Well, let me just throw in, before I turn to Michael for some guidance here, let me throw in a little twist to the hypothetical. One woman posts a comment in response to the post calling the pro-life male employee, quote, another misogynist pig who should have no opinion whatsoever on a matter of a woman's health, and she's fired for that. Now that woman comes to you, Michael, for advice, along with the male who originally posted the notice, who's also been disciplined. How do you guide them? What do you do?
Well, first I'm going to have a conflict check there if they're both coming to me at the same time, and try to figure out how we navigate that. But let me start by just addressing the hypo without the gloss. You know, and so I would say, first of all, you know, I'm going to focus more on Josh's and Heidi's comments. And as I was listening for, as a plaintiff's lawyer, you know, any red flags that I would see. And I didn't hear any red flags, but Josh and Heidi are both doing something extraordinarily difficult, which is trying to navigate multiple competing goals and concerns. And so I would say there are yellow flags, you know, on either side, because you're trying to navigate these difficult issues. I appreciated, Josh's point that the legal risk here may not be what makes the decision for you in the end, and I think that's probably the right way to view it. But that's not to say there is no legal risk. Implicitly, that suggests that there may be some legal risk on one side or the other. And so I would be looking here primarily at state protections, state law protections. And some that we haven't really spoken about in a lot of detail yet, because there are some statutory protections for speech that could be implicated. I'm not going to cover every state. I'm not prepared to do that, but I will do kind of a tale of two civil codes here, which is New York and California. They operate very differently and in some nuanced ways that I think apply to this context. So when you're talking about, New York, New York Labor Law Section 201D has some protection for political activities that the employee engages in off the employer's premises without the use of the employer's property. And it's stated in the hypothetical here that this was posted on a company forum. So we are talking here about use of the employer's property that probably isn't going to implicate the New York statute. There are a lot of reasons why the New York statute is not ideal if you're a plaintiff. It has a lot of exceptions to it. And this goes to Josh and Heidi's point about employer policies. One of the exceptions in the New York Labor Law 201D is that if the employer disciplines someone based on a good faith belief that the company's own policy prohibited the speech, then there's no liability under the labor law, which to my mind as a plaintiff's lawyer means there's almost never going to be liability, except maybe in some rare cases. So New York law is not going to help you very much. California law may be a different story in a couple of different respects. So I'll mention sort of two provisions here that are implicated, and this is going to tie back to what Dan was discussing under the National Labor Relations Act, with the second one at least. The first one is California Labor Code 1101, and that has basically two prohibitions. One is that an employer can't forbid or prevent employees from engaging in politics or becoming candidates for public office. That probably doesn't reach this comment. But there's another provision that says that the employer can't control or direct or adopt a policy that tends to control or direct the political activities or affiliations of employees. And that language has been construed a bit more broadly. And that includes espousal of a candidate or a cause. And the leading California Court of Appeals case that established this one involved speech by someone who was gay, speaking about LGBT rights in the workplace. And that was the cause that was deemed to be protected by 1101. So here we have someone who is speaking about a cause. And so if there is a policy in place that tends to direct or control that speech, arguably that implicates the statute. And so one of the yellow flags that I did come up is Heidi talked about, you may want to have something in your speech policy that deals with the terms of engagement that says, well, certain topics are off limits. I think that could implicate the statute. It's not to say this is a case I would take, but it also isn't to say that there's no plaintiff's lawyer who would. The other provision that potentially comes into play here is California Labor Code 232.5. And this one says that an employer may not require, as a condition of employment, that an employee refrain from disclosing information about the employee's working conditions. So if we go back to the part of the hypothetical where the employee is saying, well, abortion is covered under our company's health plan, Dan drew a very interesting line. As a matter of NLRA speech, you can just not avail yourself. So you're not actually trying to change anything by saying that, but you are disclosing information about a working condition, and a benefit is certainly has been deemed by courts in California to be covered by the statute. So you are disclosing information, and if the employer is saying that you can't disclose that information or has a policy that implicates that in some way, that could potentially be triggered. Now, the protection here is just that the employer can have a policy. It's probably not going to be the case that there will be something that speaks that specifically to it. But if the employer did say something like, well, you have to take that post down because we don't want people scrutinizing our health plan, that's the kind of fact pattern that I suppose could implicate this. Now, you posed the question, Evan, about the pro-choice employee reading this post, claps back at the person who originally made it and calls them a misogynist pig. So if that person comes to me, what am I thinking about? Well, first of all, I mean, just by virtue of the nature of what she said, I'm first going to be looking at the Title VII question and whether she has a hostile work environment claim. And I do agree, with the point that probably on the strength of this post alone, that's not a strong claim. If there's more, so that's what I'm going to be asking, right? Like, what else is there? Is there other speech that you're concerned about? Have you heard expressions of the employer's view on this matter? Is there anything what happened when you spoke to management about this? If you spoke to your supervisor, did they respond in any way? What was their reaction? Those are the things that are going to go to the Title VII question. But also, and this is partly as a strategic matter, I'd be concerned here that the employer is going to potentially view my client's comment, which is quite pointed, calling the person a misogynist pig, as a fireable offense. This could implicate any number of, workplace rules about respect for other employees or, decorum in the workplace. And I would want to look for a way to protect my client and say that speech is actually protected and you can't fire my client for that. So that's where I would be looking to state law protections to see if there's a political speech claim here of some kind that could be made. And most likely, under most statutes, that's not going to be implicated unless there's an adverse action taken against the employee for the comment. But again, there are certain circumstances under California law where just the existence of the policy could raise a concern.
Let me raise a question that's been posed by one of our participants, essentially asking from an arbitrator's perspective, where the arbitrator is presumably not supposed to be necessarily relying on law or trying to resolve legal questions. But how are arbitrators to address cases where employees are disciplined for violation of speech posting prohibitions, where the posting may be suspect under Title VII, under the NLRA, under the particular New York or California statutes you've referred to? What is an arbitrator to do in that situation? Anyone have any thoughts or comments on that?
Well, let me jump in. I don't know if you mean this is a labor arbitration. If it is, you're likely under a just cause standard. So that's different, and in some respects broader than the statutory protections under Title VII or the NLRA, because it obviously brings in outside factors. How long has the employee been there? Is it a good work record? So an arbitrator could obviously put a person back, even if in the most literal sense it violated, say, a Title VII, established a Title VII claim. The arbitrator could say there was simply no just cause. I think also that it's likely that the arbitrator would look to, if not for control, but look to guidance to where the board is now on this. In other words, it would follow, was it concerted? Was it for mutual aid and protection? And also, I think as to whether the statement, whether the substance of the statement could be protected, whether it was creating too much tension in the shop, whether it created issues of safety or what they call opprobrious language. I think would look to the recent board case Lyon Elastomers, which reversed the General Motors. Really, for instance, going back to the hypo here that you raised, under General Motors, most likely the statement to misogynist pig would not be protected. Now, under the Lyon Elastomers, it probably would, depending upon some circumstances that are not in the facts here. In general, how was this the first? Was it a one-off? Have there been back and forth creating a really tense environment? We don't know that from the facts of the hypo. So it would likely be a protected statement under the traditional board criteria. In particular, I would note that the pro-choice woman who posted it did tie it directly to the issue of healthcare, not to the issue of the procedure of abortion, but to the issue of healthcare, which is clearly one of the hallmark subjects of bargaining. So given that, and given the more expansive protection under the Lyon Elastomers, I think unless there was a long history here that was creating a boiling situation in the shop, I think likely it would be a protected statement. And the arbitrator, going back to the question in the chat, I think the arbitrator in this situation would look to guidance for board law, even if it was not controlling. And again, if it's a labor arbitration, there would be other factors that aren't, that we don't see here to reach just cause.
Josh or any of the other panelists have any particular response to that question? Josh, can you hear us?
I had to unmute myself, Evans. No, so I view the question as being in the context of a labor arbitration. If I was in an employment arbitration, I'd expect the arbitrator to apply the law. And so I'd be arguing about what the law says. It's just that I just live in a different world than doing this.
All right. Let me turn to another hypothetical at this point, a slight variation of what we've been talking about. A manager or the CEO in your client's New York or California office posted her support for Russia's invasion of Ukraine or Hamas October 7 attack on Israel on an external platform, identifying herself as an employee of your client company. Two members of the manager's team are Ukrainian or Israelis and have complained they do not trust that their manager will be able to treat them fairly without bias, given her views and the fact that performance evaluations are coming up. Or they publish their belief that the company should publicly support Ukraine or Israel, and then are fired for their views contrary to the manager or CEO. So, Charlotte, are there cases or statutes that come to mind when you hear this set of facts?
Potentially, I mean, this is such a is such a tough issue, and mainly for reasons that don't have to do with employment law, right? So, you know, I sort of understand when people's reaction is like employment law feels like really beside the point here. So, you know, I think in a lot of, I can certainly imagine really both of those alternatives. So the employees saying, are we going to get fair treatment here? Or the employees wanting to publish kind of a counter speech, raising Title VII discrimination questions. The kind of like counter speech version is tricky because you would want to know whether the employer has taken, you know, has allowed more permissive speech from some employees versus others based on their, you know, national origin, based on their race, based on their religion, right, based on a protected characteristic. And if so, right, then that could trigger a Title VII discrimination claim. You know, I'd also, you know, we'd been talking about kind of hostile work environment. I don't think there are very many cases that have to do with the creation of a hostile work environment based on external speech, somebody's outside speech, but there aren't none, and courts and as far as I can tell, courts will say that outside speech can contribute to a hostile work environment, although it's you know, not as strong evidence of a hostile work environment as speech that happens in the workplace. So it could be in play, but it's not so clear that the same result would occur as if the speech had been made at work. So those are, you know, so those are some of the issues I think about. I'd be curious how people would handle that based on your particular perspectives.
Well, Josh, what would you advise your client?
Well, again, it depends on the question, but here are the different things that I think about, and after I talk about that, I'm going to just talk about a couple other little things. The first is whether there is room for, or to what extent, employees' opposition to the publicly stated views of their CEOs is protected. That's a little bit where we were. And is it Title VII or not? On balance, I can see the arguments somehow that in these different contexts, you could get to the notion that this was discrimination on the basis of national origin, discrimination on the basis of religion, things like that. Do I think they're good arguments? No, I don't think they're particularly good arguments. But that's not the space that I think, and this is part of what's so interesting about this for employment lawyers. Our space has two big components. Component number one is the law. And for all of us who've done this for a long time, it's wonderful because it changes, it's different. And then there's the second part, which I think makes our practice area so uniquely fascinating to work in and also important, which is where it's about people. And we're back, and Heidi is going to get stuck with this, right? We're back to how do you build a workforce that can live in a universe where you have a CEO who takes positions that the employees can't deal with? Do you let the CEO create the monolithic space and fire people for disagreeing? Could do that, but what would the CEO have left? Do you try to figure out, from your perspective as an in-house or out-house lawyer, how to persuade the CEO not to go down these roads? Complicated, right? Depending on who you're dealing with. But there is this other question bubbling through this, and now I'll go to lenses just for a second, which is, what about a universe where so much of what people say and think is expressed externally in ways that are preserved, social media or otherwise? People lose their jobs because you think of Alexi McCannon and Globe and Vogue. She lost her job quickly because of things she said when she was much younger. Ronna McDaniel, much more public and difficult situation, and there are other issues here too, but imagine for a second that what she said was somehow, I'm not even going to bother to characterize it, but the point is not losing a job for performance, but losing.
Josh, we lost your voice.
A job for what happens outside the workspace. Say it again.
Josh, having trouble hearing you there.
I'm sorry. Evan. Oh, so in any event, I'll stop here because my general point here is I think that the employer needs to think about how to, whether and if it wants to create an avenue for dissent. But the bigger problem is, how do you make sense of external speech and how much looking at what employees say externally you're going to do, because it has a business impact and it can also have a cultural impact. Is that enough for you to move on from?
Heidi, take it from an in-house perspective. What do you do with your client in that situation?
Sure. I mean, I think what I'm looking at, I'm going to kind of take the situation of a manager in this case, not the CEO, because I think that's sort of an interesting. There's a lot of options there. If you have a manager who has a strong view on something that implicates a protected category, and that view is expressed externally, and that manager has people reporting to her or to him who belong in that protected category, I would be worried about that relationship, and I would be worried about the employees reporting to that manager. Are they feeling that things might be unfair? The hypo has us coming up on performance reviews. I'd also be worried that the manager sharing their view publicly, externally, opens them up to an accusation, even if they can put aside their political view or their whatever their view is, to in an unbiased way manage their folks on their team. So I feel like there's legal risk on both sides leaving this group together. So from a practical standpoint,
would you ever call them all in together in one meeting with HR and perhaps yourself to discuss and hash out the problem?
That's a good question. It depends, I think. It depends upon the personalities, their relationships. I think I'd have to know more about the group, the history. I'd probably first want to talk, either myself, but probably most likely it would be an HR business partner, have conversations with them separately and understand where everyone's at. If there was a long history of good relationship and this was the first real major issue, maybe some sort of internal mediation of the conflict could work. Another thing, if this is available, and this isn't always available at companies, if you can have the manager stop being a manager, but not change their compensation, not have it be in any way, adverse employment action, that they can do their work as an individual contributor and have somebody else manage the team, that takes care of the legal risk, at least on the side of the more junior employees. I'm sure Michael.
Would you consider changing the supervisory managerial roles so that the manager and the employees involved are not working together any further?
Yeah, I mean, look, I think Michael might tell me that moving the manager is automatically some sort of adverse employment action, but if the pay is the same, if they're still managing, if they're still doing comparably important work, I might take a risk on that, particularly if the manager was spoken to and consented and understood that was, something for his or her protection as well.
Can I go back to the meeting in the same room thing? Just as Michael talked about yellow, red flags. I've had a number of cases where that response, we're going to get the people together, has been characterized by the plaintiff as retaliatory.
Yeah.
And I think that you just would want, before going down that road, to think about what the nature of the underlying claim is, to what extent being put in a space with the other person would have been, think about Burlington Northern and the standard. Is this the kind of thing that would have led somebody to choose not to come forward with a complaint? And just make yourself think through the retaliation question before you do it.
There is no circumstance where we would have employees get together and sort of engage in what I call sort of internal mediation unless they both very much consented and thought it would be productive, and they would be given the option if we even thought it was viable. I mean, there would be a lot of steps before we would get folks in a room together. And like I said, it would really depend upon the existing relationship, prior to this comment. If these folks have been working together 10 years and had a long history of really positive relationship, and this was one upsetting event that happened, they both might be more willing to talk because they've got sort of that credibility with one another versus a different, shorter, more fraught relationship where I probably would not want to get them together in the room. I think you're absolutely right, Josh. It could really put pressure on the more junior employees and discourage future reporting.
So Dan, let me throw the question to you. Let's assume that these employees are part of a union that represents the bargaining unit of the employer, and they come to you. They go to their union first, obviously, and then the union comes to you. What do we do here? Do we have a grievance? Do we take this to arbitration representing the employees? What's our remedy?
Well, I think in the unionized arena that, let me jump back one step. Clearly, the speech is not NLRA protected. There's no question about that. It doesn't have NLRA protection. But if they're part of a bargaining unit with a collective bargaining agreement that most likely has a just cause standard, then they do have the right to grieve and assert that there's not just cause for the termination. The employer might cite a policy about political speech, but that can be countered by, again, reference to who are these employees, how long have they been there, is this really a basis to discharge? So it would give these workers
not just a discharge, but also the employees are concerned the manager, who is their manager, is going to give them bad performance reviews.
Yeah, you would have through the grievance procedure and arbitration the right to challenge the basis, the bona fides of the review. So there would be protection for these workers, even though the speech itself is not NLRA protected. I'd also, Mike mentioned before about New York Labor Law 201. They wouldn't find protection under that either. And I think he outlined before that the law, while good on its face, has a lot of loopholes. There was a case, I think it was in the news, a New York City police officer, I think it was fired for activity on October 7th, January 6th in Washington. And he was fired by the police department. He was also brought up on criminal charges, but he argued to put aside, to reverse his termination, that he argued he had a right to make the political speech under Labor Law 201. But the court was very clear to say that the speech that's protected under that is very limited speech. It's related solely to running for political office or supporting a political candidate or participating in fundraising, and that the courts were not prepared to go broader on that and make it as a broad brush political statements. Let me say one other thing. I think the debate and the discussion that we've had this morning highlights an interesting distinction between employment law and labor law that we should always keep in mind. That particularly when you listen to Heidi and Josh about how you have to, if you're representing individual employees in potential employment actions, how you have to jockey to weigh the competing rights and interests of these individual workers. One of the values of having the collective bargaining setting is that even if the speech is not statutorily protected under the National Labor Relations Act, having the union forum provides a mediative forum where you can bring workers together into the same room with employers to try to reach common ground on that, so that you're not dealing with atomized workers raising atomized claims that you can't reconcile. And that's one major distinction between the two areas of law.
Let me throw out. Yes, Michael.
Evan, I'd like to just jump in here. So there's a couple of points that I want to make. One is just on New York Labor Law 201D. This is not really applicable to the facts as they've been stated, but if we tweaked them slightly, it could be. And this actually speaks to an interesting trend in new statutory protections at the state level. There is also a provision of New York Labor Law 201D that prohibits employers from taking adverse action against employees who refuse to attend employer-sponsored meetings or view communications from the employer that communicate the employer's opinion on religious or political matters. And what that I think is really aiming at is captive audience meetings, particularly in the union organizing context, where historically it has been allowed under the National Labor Relations Act for employers to hold meetings where they express anti-union views to employees leading up to an election or other organizing activity. And that's, I think, what these were sort of initially aimed at, but it could be implicated by a situation like this one as well. If it's not an external platform, if this is a speech being given at the workplace or a communication sent to employees, you need a few more facts here for this to really tee up the statute. The person would have to somehow object and then be fired for objecting. And again, New York labor law has various, exceptions and loopholes in it, but there are other protections like this being passed at the state level in many states. And so that is something to just be aware of and put on the radar in terms of the many concerns that employers would have to navigate in a situation like this where the CEO or a manager is expressing a view. I do think, again, and this is speaking to Heidi and Josh's points about the Title VII context, I agree this is probably not a situation where the employee has a strong claim yet, which is why I take it Heidi and Josh were saying, well, but you might be a little concerned about like what comes next, and we may want to manage the situation so it doesn't continue or get to a point. I mean, if there are performance reviews coming up, you may not want that manager evaluating the person. Because if they get an adverse performance evaluation, they can say, well, this was because I disagreed with what he said about Ukraine. And so I think that is the right move from an employer's point of view, is to try to take some steps to limit that. Are you then going to face a claim from the supervisor that they had a diminution of their responsibilities? Maybe. We've made arguments like that. I think you would want to really flesh that out as a plaintiff. I think you would want to be able to show that by being in that supervisory position, you were in line for further promotion or advancement in the company, or that it limited your employment prospects long term. I think probably you want to have other claims that you're bringing with this. It's probably not a case I would take on its own.
Well, what about the reverse? So as opposed to the supervisor complaining, imagine that our supervisor is actually incredibly influential, and people who work for that supervisor have succeeded in being promoted at a better level than others. And in order to solve the problem, the employer does what the employer often does, which is to move the supervisor. Can the plaintiff then say, wait a second, you've just effectively taken an action against me that's going to limit me in a way. You need to make him or her behave differently. You can't change my path to success.
That's a creative argument, and I like creative arguments. It's not one I've seen made. I don't know. That seems like it would be a bit of a reach.
This is what always happens, by the way, to defense counsel. We come up with these arguments that we worry about. And then I love the reality test of the plaintiff's counsel, because now next time that I worry about this with someone, I'm going to worry less. Thank you.
Well, again, just because I wouldn't take the case doesn't mean that nobody else would. But
okay, let me exercise moderator's prerogative here. And as we're running short of time, there are a couple of cases and points I'd like to just mention for the audience. First of all, the NLRB has recently issued several decisions involving employees wearing aprons and markings at the Home Depot store stating BLM, which is short for Black Lives Matter. Two ALJs at the NLRB in two separate cases, one involving Whole Foods and the other involving Home Depot. The two ALJs, administrative law judges, found no violation of the National Labor Relations Act. In the Home Depot case, and the most recent was on December 20, just recently, December 20, 2023. But on February 21, just a few weeks ago, the NLRB handed down the decision finding that Home Depot had violated the NLRB by disciplining employees who refused to take off the BLM initials from their orange aprons issued by the respondent company, contrary to the administrative law judge in that case. Interesting developments, which could give rise to a whole additional new webinar on the topic. Former NLRB official Jerry Hunter has sent in a question to us asking, in view of these decisions and the NLRB's recent Home Depot decision, would it be a violation if the employee wrote WLM or ALM, White Lives Matter or All Lives Matter on the apron and refused to take it off? Well, I guess that will be decided by some future case down the road. I'd also like to point out that the New York State Legislature has just issued, on September 6, 2023, Governor Hochul signed a new law into effect, which creates a right for employees to refuse to attend any employer mandatory meetings, to refuse to listen to communications regarding the employer's opinion on religious or political matters. And the legislative background and history of the bill shows that it was specifically intended to include, under political matters, mandatory talks by employers concerning upcoming union elections. In addition, Jennifer Abruzzo, the general counsel of the NLRB, issued a short while ago a memorandum, GC 22-04, stating, I plan to urge the board to reconsider precedent and find mandatory pre-election company anti-union speeches to be unlawful. I think these raise interesting questions concerning free speech, and we're going to hear a lot about this going forward. We have perhaps a few more moments if any of the speakers, panelists would like to add any final comments or statements. Go to it.
I'll just mention on the statute that you raised, Evan, which is the amendment to 201D that I was referring to. There are clearly interesting labor law preemption arguments that are going to come up here. And there will be questions about whether or not, for example, states have the right under traditional state police powers to prohibit certain kinds of meetings, and whether that's going to be preempted by NLRB doctrine.
And yes, Charlotte.
Oh, I can talk a little bit about the Home Depot case, since it's close to home for me. It's a Minnesota-based Home Depot store. In many of these cases, the issue is whether the speech is sufficiently connected to workplace issues, and I think that is, can be a difficult question. But that wasn't really a difficult question in the Home Depot case, because this played out, right? So the employees wrote BLM on their aprons, like in the context of a specific and ongoing set of collective action related to discrimination in the store. So the issue the harder issue in the Home Depot case was actually concertedness. The individual who wrote, an individual who was fired after writing BLM on their apron, had been participating in the concerted activity, but also took that decision on their own. And then a couple of other employees kind of followed suit. And so this was really a case about whether that was a logical outgrowth of the prior concerted activity. The court said yes. The board said yes. Harder issue, right, where this isn't happening in the context of a specific dispute about discrimination by managers or a hostile work environment created by customers or coworkers in the actual store. On the issue of whether there's some kind of like a viewpoint discrimination issue that relates to, on the issue of sort of if an employer has to allow anti-racist speech, does that mean it also has to allow racist speech? I tend to think the answer is no, because of course Title VII still applies. So an employer that has to allow, an employer that, would violate the act if it prohibited writing BLM on an apron would not necessarily then have to allow, would not have to then allow speech that violates Title VII.
Just one point to that, Charlotte. I think one thing that makes these issues very difficult, especially in the interesting times we live in, is that you have a lot of competing claims about what the speech actually means. And so, you framed it as, if the employer allows anti-racist speech, do they have to allow racist speech? Well, some people would say, well, saying all lives matter is not racist speech. And other people would say, well, it is, for various reasons involving context and history. And that's what I think makes these issues, one of the things that makes these issues so difficult, is that we have competing claims about what the speech actually means. And you could apply that in any number of other contexts involving, international politics and, domestic politics. That applies across the board.
Let me throw out for all participants and all of the attendees the CLE number. The CLE code is S as in Sam, 2587. That's SS 2587. And let me wrap up with throwing out this final comment for the panelists. Of course, we don't have time to discuss it, but let's assume the company policy says everything we do with this company is confidential, everything. We do not talk about the work we do, the products we're developing, or our unique culture internally to anyone. Yes, anyone. That includes your spouse, your mother, your friend, the reporter, everyone. This confidentiality restriction applies after employees leave our company and continues indefinitely. That's the company policy. And I leave all of you with the question, is that a legitimate policy? Can that be enforced? Will the courts enforce something like that? Will the unions take issue with it? And I think, as I said, that would be for another time. We're at the end of this program. I'd like to thank all of our participants, our panelists. I'd like to thank the College of Labor and Employment Lawyers for sponsoring this, particularly Susan Wan and Jen Motley at the college for helping to put this together. And I'd like to thank our friends at Seyfarth Shaw for taking care of all the CLE requirements. Don't forget to get your CLE requests in. The CLE code again is SS 2587. And with that, I thank all of you, Charlotte, Heidi, Dan, Michael, and Josh. I appreciate very much your participation in the program, and I think it's been very educational for everyone. And I believe that that brings to an end our panel.